This video offers insight as to when and why a business may be well served by hiring an independent workplace investigator. The assessment of whether to do so should be made anytime circumstances require the review of a complicated workplace issue prior to deciding on appropriate disciplinary action. Consider the dreaded sexual harassment complaint. As an employer, if you haven't been confronted with this situation yet, well, you've been lucky so far. Most employers who have learned four fundamental truisms, sometimes the hard way. First, complaints don't go away or become less serious by ignoring them. Second, the complaint typically isn't the product of one isolated incident, but rather involves an extensive backstory that can be complicated and confusing. Third, separating fact from fiction, logic from emotion, and reality from expectation is hard. Really hard. It takes time, training, and practice, which quite frankly most employers don't have the time or opportunity to get. And fourth, no matter what outcome you reach, the decision is likely to be unpopular and possibly be challenged by at least one employee, and if you really miss the mark, perhaps by more than one. Most companies have the capacity to handle day-to-day workplace concerns. However, when confronted with a complaint about a complicated workplace issue, including concerns regarding thorny policy and legal violations, or complaints of sexual harassment and other forms of discrimination, a thorough investigation by a trained independent workplace investigator is crucial. Why is that? I'm glad you asked. Guidance from the Equal Employment Opportunities Commission provides that in all circumstances of alleged discriminatory conduct, employers must conduct a prompt, impartial, and thorough investigation. But how do you know what's sufficiently thorough to meet your legal obligation? And perhaps more concerning, how can you demonstrate that your internal investigation was impartial? Most businesses, even those with a well-staffed human resources department, don't have employees trained in performing effective workplace investigations. Even those that do must consider that, given their relationship with the company, the impartiality of internal investigators' efforts are, at the very least, generally viewed with deep skepticism. So what does a trained independent workplace investigator bring to the table? First, by virtue of training and experience, an investigator can plan an effective investigative strategy, undertake a critical review of documents, conduct unbiased witness interviews, and perform a complete and objective analysis of the information obtained in order to reach a conclusion that is fact-based and defensible. Depending on the employer's needs, conclusions can be presented orally or more typically by way of a detailed written report. Second, and this is very important, a truly independent workplace investigator will insist that the performance of an investigation be conducted without influence, pressure, or guidance by the company requesting the investigation. Why is this important? It ensures fairness. I have yet to meet a business that initiated an investigation with the goal of being unfair to its employees. And yet, employers all too often fail to recognize situations where internal investigations suffer from inherent bias. Employees, on the other hand, are quick to discern this. Indeed, they perceive the outcome as a foregone conclusion. The same problem exists if an external investigator conducts the investigation under the direction of the company, or if the hired investigator is someone who has a close relationship with the business, such as the company's existing legal counsel. Only by working independently, free from actual and perceived bias, can an investigator's decision honestly be viewed as objective. Finally, hiring an independent workplace investigator protects the attorney-client relationship shared between a business and its existing legal counsel. One of the significant purposes of conducting a prompt, thorough, and impartial workplace investigation is that the employer's reliance on the results of such an investigation may be presented as a defense in the event of a subsequent employment claim. However, in order to rely on this defense, the investigation, including any report generated, must be disclosed. This requires a waiver of attorney-client privilege, something a company's general legal counsel, for good reason, may be disinclined to do. However, when the investigation is performed by an independent investigator, for instance, an attorney with no ongoing attorney-client relationship, the concerns with such a waiver are eliminated. All communications between the investigator and the employer relate to the single issue under investigation and confirm that the process was conducted in an unbiased and impartial manner. In other words, the disclosure supports a determination that the investigation was fair and reasonable. When defending an employment action, an employer can't hope for much more than to be able to demonstrate that the action it took was based on a fair and reasonable inquiry. And now you understand the power and importance of hiring an independent workplace investigator. For more information on workplace investigations, feel free to contact Jeff Bubendorf at Brown Jacobson's Employment Practices Group.